Hey, thanks for making it to Veterans Info Tap. I'm glad you made it. Another case going before the Supreme Court. Now remember, we just saw the ruling for a recent Supreme Court decision where they ruled in favor of veterans regarding the utilization of both Montgomery GI Bill as well as post 9/11, using those combined for a total of 48 months. There's a new one coming, and this is going to be important. The headline is saying that the Supreme Court is to hear cases on veterans benefits along with a couple other things next term. So that is going to be something that we need to keep an eye on, because it could absolutely change how benefits are being handled by the VA and for the benefit of veterans. So with that, please hit the thumbs up, subscribe, share with a friend. Every minute watched, every thumbs up helps the channel. If you want to support in other ways, you can become a member. Go to the homepage, you'll see the highlighted members there, and you can hit the join button. I really appreciate any additional support. It really does help the channel. All right, so with that, let's dive into this, see what we can ascertain, see what kind of nuggets we could find, what rocks we could turn over, and so forth. So I found that this article specifically was on Washington Post by Justin, I don't know how to say his last name, Jovenol. And this came out April 29th, 2024. Supreme Court, that was just yesterday from the date that I post this. So Supreme Court to hear cases on veterans benefits, pet food, and visas next term. Don't really care. I mean, whatever. You might care, pet food and visas. But my focus, obviously, here is veterans. So let's jump into this article and see what we got going on. All right. The Supreme Court on Monday added cases to its calendar for the term beginning in October. So that's the new fiscal year, which is around the corner. What is it, 6 months or so? Beginning in October, the deal with veterans benefits, civil liability, immigration visas, and pet food consumed by a dog named Clinton and a cat named Sassy. Whatever. It's what the article says. So again, I'm going to focus on the veteran piece, but there will be some sprinkling in of these other issues, apparently. All right. So in a case that could have significant implications, for those who serve in the military, the Supreme Court will weigh a matter involving two veterans who argue they were improperly denied medical benefits for treatment of post-traumatic stress disorder related to their service. Now, what could this mean, and how can this unfold? I mean, so far, we don't have a lot to work with. However, if you're being denied medical benefits for treatment of PTSD, post-traumatic stress disorder, related to your service, I would venture to say maybe the VA was not recognizing the PTSD as a service-connected condition, and therefore we're not treating these veterans, which that would not be good. So curious to see where we're going with this. Let's roll into it here. Joshua Bufkin, who served in the Air Force from 2005 to 2006, and Norman Thornton, who served in the Army on active duty from 1988 to 1991, say they should get care under a benefit of the doubt rule that requires the Department of Veterans Affairs to provide access to treatment when it is a close call whether the applicant qualifies. So what they're talking about here is that rule that most of us are aware of, which is if the evidence is in equipoise, meaning it's equal on both sides, the VA is supposed to rule in your favor. So it moves on here to say both cases had evidence for and against them receiving benefits. So let's take a sidestep here for a second. If you are filing a claim with the VA for anything, this is talking about PTSD, but I mean really anything, your back, your neck, your hip, your GERD, your migraines, it doesn't matter. You have to provide documentation. That documentation that you're providing to the VA is proof of your condition, and the nexus, the link between the condition and your time in service, is considered evidence. Now, there's going to be evidence that's for you and evidence that's against you. My mind says, look, every piece of evidence that I submit for a claim is going to be for me. However, sometimes people just randomly grab stuff and send it off to the VA, or, in my opinion, worse, sign over authorization to the VA to say, get anything you need from my doctors, all of them. Every single word and note, and that one day that I was feeling better and I had that written in my file, please take that all. Well, that's great, but you have no clue, and I really doubt that you know exactly what's in all of your medical files as far as your civilian provider is concerned, for sure. You don't have any control. You don't know what they have, and it's going to be used for you and against you. So what happens is once they stack everything up, including your CMP exam, once they stack it all up, it's going to kind of be weighted. If it's not clear cut, that's a service-connected condition. The nexus is clear. You were diagnosed for whatever, sleep apnea, halfway through your time of service by a military doctor, in fact, right? That would be a very easy nexus, very easy. You're diagnosed already. That's easy. Most of us don't have that situation. We have I stayed away, I never wrote anything down, I self-treated, I took handfuls of Motrin, I drank, whatever it is, right? And you pushed through, and that's how you got through it. So you don't have that hard evidence for the nexus. So you have to manufacture evidence with buddy statements and so forth, and a nexus letter from your doctor, and you're trying to build that evidence on your side for you. You go to the CMP exam, maybe the CMP examiner rules against you. Well, now you have competing evidence, okay? If the CMP examiner says no, not service connected, but you have a nexus letter from your doctor that says yes, service connected, well, are those doctors, right? And on face value, you think, okay, well, I have one that says yes, a doctor, and I have one that says no, a doctor. Well, if the CMP examiner has a higher designation and is, we'll just say, a specialist in neurological conditions, and you're filing for migraines, and you have a nexus letter from just a standard primary care physician, the VA is going to rule the neurological doctor, because they're a specialist in that field, with more weight. Therefore, the evidence is not equal, right? The nexus letter and the opinions of both are equal, but where they're coming from is different, right? So anyway, that's a very important piece of this pie. So I wanted to dive into that you must make sure that you are providing the best evidence at the highest level you can. If you're denied, you need to figure out why and where the weight is given and try to overcome that. You might need to go see a specialist and have them write you a nexus letter, for example. All right, moving on. Both cases had evidence for and against them receiving benefits. The U.S. Court of Appeals for Veterans Claims denied their appeal for benefits, saying there was no error in applying the benefit of doubt rule. Another tidbit here, I will go through this fast. You have the ability to file your claim with the VA. If you disagree with the VA, you can ask for a higher level review. You could then ask for a supplemental claim, which is you applying more evidence to your claim and letting them re-look at it, essentially, with that additional evidence. If they deny you again, you can push it to the Board of Veterans Appeals, right? So the BVA, you can push it there. The Veterans Law Judge will look at your case, and if they deny you, you still have another go. You can actually move from the BVA, Board of Veterans Appeals, and push it to the U.S. Court of Appeals for Veterans Claims. Now, if they deny you, that's where you can try to push it up to the Supreme Court, and that is where we are today. So let's move on here. When that decision was reviewed by the U.S. Circuit Court of Appeals for the Federal Circuit, the plaintiff said the Court of Appeals ignored a 2002 law bolstering the Veterans Claims Court enforcement of the benefit of doubt rule. That could have cleared the way for them to get care. The Supreme Court will review the Court of Appeals interpretation of the 2002 law. In a second case, the High Court will parse the scope of a federal law that allows plaintiffs to recover civil damages when they suffer economic harm. Now, here's the thing. Going back into this, because I think it's starting to segue out into the other, I'm just looking here real quick. Yeah, it doesn't look like it's veteran stuff anymore. It's moving on to the other issues. So, back into this, the big kind of takeaway here is the Supreme Court going to rule in favor of these veterans with a more liberal stance, apparently, than what the VA had, the BVA had, and the U.S. Court for Veterans Appeals had on the benefit of doubt rule? Will this open it up a little bit? And I'm going to tell you this real fast. This is the type of stuff where, again, this is what affects the vast majority of us when it comes to filing a VA claim. You go to file your VA claim and you don't have all of the hard evidence, so you have to, again, manufacture. You are, maybe you served at a base, for example, that had Agent Orange, and they used it to spray down the weeds there. I did an example on this the other day on Fort Ord there in California, how there is documentation. Even the Army Corps of Engineers found traces of chemicals that are used in Agent Orange, and there was other publications, some news articles, some before and after pictures of the usage of Agent Orange to combat the foliage there, specifically poison oak. I guess there was a lot. And that is all evidence, right? So as you're building your evidence that Agent Orange was used there, you served there, and now you have a condition that's associated with Agent Orange but not presumptive because it's in Fort Ord. Now you have a leg to stand on when you file your claim. And when this claim goes through, you're relying on the VA or the Board of Veterans Appeals and so forth to look at the evidence supplied by you and brought forth by the VA to go, yes, your claim is service connected, or no, it's not. The more things that you can bring to the table, the better. But this court case with the Supreme Court that's going to be happening this next session is really going to impact that benefit of doubt rule. So we're really going to be curious to see how this unfolds. With that, thank you so much for watching. I appreciate you. Have a great one. And remember, if we don't take care of each other, something went wrong.